Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you from our fantastic Central Washington location. Been a while since we got here. Listen, I want to talk to you about a very, very strange, troubling, and bizarre ruling we got out of the state of Massachusetts earlier in the week. It has to deal with a challenge to Massachusetts' assault weapon ban, and we are beginning to see all sorts of creative new rules of law, none of which have any precedent cited to them, I should point out, as to how these blue states and these people who are favoring civilian disarmament can continue to uphold what we all know to be unconstitutional bans under Heller, Bruin, and candidly the Second Amendment. A judge in Massachusetts has come up with a whole new way to do it, and it is bizarre, it is troubling, it's kind of stupid too. So today, let's spend a few minutes and let's talk about yet another way they will try to uphold assault weapon bans. Okay, so the case we're talking about today is Capon v. Campbell. It is a challenge to Massachusetts' ban on semi-automatic rifles and magazines which hold more than 10 rounds. It was argued before the Honorable Dennis Saylor IV, who I should point out is actually a George Bush appointee. Now, in denying the motion for a preliminary injunction, the good judge found that obviously the plaintiffs were not likely to prevail, and they were not likely to prevail because he found that assault weapon bans fall into a rich and historical tradition of banning flat-out platforms of firearms. And worse yet, he took a whole new twist, a whole new deviation on what we call the dangerous and unusual test. As the good judge found, the banned weapons are dangerous because they are unreasonably dangerous for ordinary purposes of self-defense due to their extreme lethality and high potential for collateral harm. And they are unusual because it would be unusual for an ordinary citizen to carry such a weapon on his person on the street for self-defense, or to use it in the home to confront invaders or to protect against personal violence. And this, of course, is in a long, rich, recent history in which many judges, for some reason, think that once they put the black robe on, they know what firearm is best for your personal self-defense. Now, most judges have tried the end around by just saying that these firearms are not in common use or these firearms are not in common use for self-defense, both of which, as we know, are complete farces. However, this judge has done so by ruling that these firearms are dangerous and unusual, and therefore there is a historical tradition for banning their sale and possession. But as the judge put it, in short, the AR-15 is a weapon with the same basic characteristics, functionality, capabilities, and potential for injury as the standard issue rifle for infantry troops. It can be fired in the same way that military forces recommend that it be used for maximum effectiveness. What? Yeah, that is exactly his ruling. But oh, no. The bizarreness does not stop there. There was more. Rather, it is a fact that the design and features of an AR-15 compared to a typical handgun makes it an unreasonably dangerous and unusual weapon for ordinary self-defense purposes. First, the intrinsic characteristics of an assault weapon makes them poor self-defense weapons. AR-15s are physically unsuited to typical self-defense scenarios. They are significantly heavier and longer than typical handguns, making them less concealable, more difficult to use, and less readily accessible, particularly for an inexperienced user. They are not generally useful or appropriate weapons for ordinary citizens to keep at their bedside or to carry on the city streets as they go about their daily business. You literally cannot make this stuff up. This is a judge who basically is ruling, hey, the handgun might be appropriate for self-defense. Anything that's not comparable to a handgun, no, it's then dangerous and unusual. And apparently his honor appears to be somewhat of a ballistics expert because he goes into, and I should point out there was no evidence on the record here, but he goes into the fact that the velocity of a typical semi-automatic rifle round, which again, that could be varying things, but the velocity is far too powerful for self-defense purposes, as the judge put it. Indeed, a round fired from the AR-15 distributes less than half of the kinetic energy of one fired from a hunting rifle. In other weapons, the higher kinetic energy is distributed in part to the shooter as recoil, which necessarily disrupts follow-on shots. In an AR-15, however, the lower kinetic energy means that rounds fired with high muzzle velocity can also be fired in rapid succession on precise target, even while standing or moving, because the shooter's position is relatively unaffected by the recoil of each shot. Less recoil translates into more rounds on target and thus greater lethality. It also translates into far more effective to protect yourself and your family and not endanger others. So, by His Honor's own analysis, the AR-15 is absolutely inappropriate for self-defense because, well, candidly, you might be able to put shots on target. But a .44 Magnum revolver, well, hey, that will be just fine. Listen, this is yet another dangerous development here, and as these courts continue to try to find workarounds to the simple fact that the Constitution does not permit the banning of common platforms of firearms. This one is perhaps the most creative, most dishonest, and most disgusting one yet, but hey, let's give it a couple more weeks. We'll probably find another one. The case, once again, is Capon v. Campbell. We will carefully watch this case to see where it goes. We will link up the pleadings down below so you can geek out on them for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is right down there in the description box as well. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.